In this video I want to talk about time limits and time limits in relation to bringing a claim to the Workplace Relations Commission. The vast majority of cases to do with employment law in Ireland, if you have a complaint, you bring it to the Workplace Relations Commission, and you must do so within 6 months of the breach, of the alleged breach. So if, for example, you claim that you were unfairly dismissed, then you must bring your claim within 6 months of the dismissal. Same story applies in relation to allegations of discrimination or organisation of working time breaches and so on. However, if you're out of time, if you're out of the 6 months, if you fail to do it within the 6 months, the adjudicator for the Workplace Relations Commission does have the authority or the jurisdiction to extend that 6 months to 12 months if and only if you can show reasonable cause for the delay. What is reasonable cause will depend on the particular circumstances, but you do need to show reasonable cause. There was a recent case there involving a driver, a lorry driver, and a fuel company. He brought a number of complaints against his employer, his former employer, who he had left. But he lodged his complaint some 11 months and 12 days after leaving the job, after his last day at work. When he went to the WRC, he was met with a number of predictable preliminary objections by the legal team for the employer. The most obvious and basic objection was that the WRC did not have jurisdiction to hear the case because the employee in question had submitted his claims too late. The question then that arose is, what reasonable cause could he show? Basically, the driver gave evidence that the working conditions and his experience with the particular employer was so bad that he had suffered physically and mentally and was incapable of submitting the claim within the 6 months. He produced a medical report to that effect, and he actually brought along his GP, and his GP gave evidence that the gentleman had fully recovered or recovered back to himself after 8 months or thereabouts. But if he recovered and was back to himself after 8 months, there's an unexplained gap there between the 8 months at which point he had recovered and the 11 months at which point he submitted the claim. So this was something that the legal team for the employer obviously made hay with, quite frankly, and it was an argument which the adjudicator accepted and couldn't get his head around either, and on that basis the adjudicator decided that he couldn't hear the claims because the employee had failed to show reasonable cause for the delay and for the failure to submit within 6 months. The most important case, or one that was referred to time and time again as being the test, as it were, for what is reasonable cause, is a Labour Court determination in a case called Cementation Skanska versus Carroll. That's a Labour Court case. It contains the well-established test of what is reasonable cause, or what is considered to be reasonable cause. There was 5 complaints knocked back or knocked out of the park on that basis. There was one other complaint that he had. It was a Minimum Wage Act complaint. And when you are making a complaint about minimum wages or not being paid the minimum wage, you must first serve a notice on the employer looking for your average hourly rate of pay in respect of the relevant pay reference period. So you have to request that, and if the employer fails to provide you with such a statement, then you can submit your claim. But you must let the period during which the employer can provide you with that statement elapse. In this case, the driver was so far out of time that he didn't actually wait for the time period to elapse for the employer to give him the statement, and he submitted his claim. And on that basis, the legal team for the employer had another preliminary objection in respect of the minimum wage claim, and that was that he had failed to wait the requisite period of time to allow the employer to provide him with a statement. That being the case, then the case couldn't be heard, because it says the Director General of the WRC shall not entertain a dispute in relation to an employee's entitlements under this Act, that's the National Minimum Wage Act, unless the employee has obtained under Section 23 a statement of his or her average hourly rate of pay in respect of the relevant pay reference period, or having requested the statement has not been provided with it within the time limit by that section for the employer to supply the information. So he hadn't waited the time. So there are 6 claims that the employee brought to the WRC, the Workplace Relations Commission. 5 of them were knocked out of the park on the basis that he was out of time, and the 6th one was prevented from going or being heard because he failed to fulfil the requirements of the particular Act in question, the Minimum Wage Act. Hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, just hit the subscribe button. Thanks for watching.